Hi guys, it's Kathy. Welcome to Wednesday night. So, this part I have not seen yet because I just got off work a few minutes ago. So, we are going to watch this together. I'm pretty sure that Attorney Bell is on the stand the whole time. I'm pretty sure that Attorney Bell has not proven his case yet or supplied any evidence that I could have seen. Conjecture, maybe. A huge stretch, yeah. But evidence and proof, no. And I so want him to be right. But so far, nothing. Not even a little bit. Maybe a little bit. But hopefully today they have proof. Something. Proof. So let's go. Let's see.
Mr. Duckett.
Thank you. So we left off, we were talking about the Murphy case. Did Judge Rubino ever issue an opinion?
Yes, he did.
Can you refer to Exhibit 27, and that would be date number 593.
I'm here.
Is that document?
This is Judge Rubino's opinion that he wrote, denying Ms. Murphy her a right to a trial and blaming me for everything that he didn't blame me in this motion. Excuse me, not this motion, this opinion. He denied Ms. Murphy's summary judgment, granted the city's motion for summary judgment, and he said I need to blame myself for not deposing King earlier, because I would have found out they had a policy or something like that. And I disagree with this opinion strongly. I don't think it's based on the facts. If you actually read the depositions and the information submitted to him, I think that this is not supported by facts.
And when you said, you said it blamed you for not deposing King earlier, is that the same Lieutenant King that you tried to depose?
And he left, yes, and when he refused to attend the deposition, and when I asked Rubino if he could sanction them, I didn't want him to harm the city. Well, look, if I spent $1,100 or $1,200 on a deposition, can you at least tell him to pay it back? We talked about that earlier. He excused them from attending the deposition, but gave them a warning, he'll do it again. But I was trying to comply with all of the rules and get all the information that I needed to support Ms. Murphy's case. I did that early on, and when the city didn't want to follow the rules, he let him off the hook, but blamed me for it.
Did he make any comments in his opinion? Do you recall any comments in his opinion regarding the city's conduct?
He didn't say nothing about it. Everything was my fault. But he did mention, I could actually show you. It's douche machina. I'm sorry for not pronouncing it properly. I never used this word before, but I looked it up. Let me see. It is on page 598, and it is, let me see, the first full paragraph in the middle of the page, when he says, in the light of the seemingly deus ex machina nature of the revelation. And if you look at that word, that means something unexpected and unlikely. And he's talking about the city's discovery of Healy and a new policy that they never knew until the night the motions were due. And he still blames me for it. Everything's my fault. He didn't criticize the city at all. All the criticism was directed towards me.
And you mentioned earlier that you were financially sanctioned.
Yeah, oh, he told me to pay $5,000 for filing the motions for sanctions, because I filed, I filed a motion for sanction on King for changing her story, for Janet for producing Healy and submitting him as submitting his declaration as evidence after she knew he didn't have knowledge, and for Kane for objecting like 129, either 29 or 39 times at the deposition, instructing his client not to answer, and just violating the discovery rules of discovery. The discovery rules concerning depositions. And the motions are very short. If you actually look at them, they're like 5 pages of these. They're not like long. I didn't write a Bible size like motions. I just, I filed the motion. He blamed me for it. He granted the cities so when I filed my motion for sanctions, the cities they returned or they responded by filing the same motions. So we had a motion war, and he blamed me for everything. I didn't delay the case. He said I delayed the case. I don't think that's in his order. That's in his order granting the city sanction. I didn't delay the case. And I just reported to him what happened. And if you look at my motions, they have documents attached to them. I wasn't just talking. But everything is my fault.
Essentially, that is what ended the case, right? Granting their summary.
Yeah. I mean, we appealed, but appeals are rarely successful. So, but yes, that ended the case. That ended that controversy. Yes, it did.
Understood. I'd like to move on to the Miller and Myers matters. Can you briefly tell us about the facts of Myers and Miller's cases?
All right. Is it okay if I summarize it? Because we talked about this yesterday. I'm trying to get to the point. I'm sorry.
Yeah.
All right. So Miller and Myers was filed at the same time, one right after the other. Not simultaneously, but a couple minutes apart from each other. So in the Miller case, and I'm only going to is it okay if I just say facts that we didn't discuss as far as the factual backdrop of it?
As briefly as you
All
can.
right. Okay. So, Miller was arrested by Detective Craig Coulter, and Craig Coulter arrested Mr. Miller because he wanted to find out what information he had concerning the crime in his neighborhood. And Mr. Miller was sitting in his car, and the detective and they were looking for a criminal. They were looking for somebody who had some type of criminal stuff. And they grabbed Miller, arrested him. He had his firearm on him. And Mr. Miller's a law-abiding man. You don't have no record, no criminal issues. And he brought him to the station. He held him for 8 hours and just interrogated him about information he had about people in the community. The detective acknowledged at depositions that, Mr. Miller was never involved in any criminal activity. He didn't even suspect that he was involved in any criminal activity. He just wanted to know the detective wanted to know what Mr. Miller knew about people who they were looking.
Bobby, I'll share my coffee with you. You just gotta fight me for it. Go ahead. Touch my coffee. Go ahead.
Looking for in the neighborhood. And the detective admitted that he told the gun permit unit to revoke Mr. Miller's gun license. However, he in his the white paper he sent to the gun permit unit, he wanted them to revoke his gun license because he allegedly committed an armed robbery. Mr. Miller didn't commit no crime at all, nothing like that. But on the paper, they revoked his gun license because my client committed an armed robbery that never happened. And we did try to get the gun, contrary to what the city alleged. We tried to get it, but they said he got convicted of an armed robbery. You got to take this or he got arrested for armed robbery. You got to take this to court. We're not giving him a license. So there was that. And yeah, he was detained for 8 hours. His car got towed, and he had some towing fees and stuff like that. But we were in that case. We were seeking punitive damage in addition to compensatory damages. For the just blatant false arrest and detention for 8 hours. So when I filed that complaint, and the complaint is proper, you can look at the complaint, nothing wrong with it, it complies with the state law and everything. We sought damages in excess of $50,000 on, I don't remember how many counts. I know it was assault and battery, and those are the state variants of like a Fourth Amendment violation, because Pennsylvania, you can't sue for constitutional violations because we have common law causes of action that are sufficient to cover like the federal court's Fourth Amendment version of searches and seizures. And this is a Smith case, state court. I don't remember the whole name of it. So that's Miller. Now,
one quick question about Miller before you move on to Myers. Do you know how long his gun license was revoked?
I think he just got it back. because, yeah, he just got it back. He just got it back. Because they wrote him that he had a gun, he committed an armed robbery. So the gun permit unit, they not, I don't blame him either. Yeah, they said, no, we're not giving you, you're gonna have to comply with the law. And it was some type of procedural thing, I don't remember. He reapplied, I said, can you reapply? And it was some rule that said he had to wait because, I don't remember, man, but it was some type of, it was a monkey wrench in it. He couldn't just get his gun license back. They wanted to hear him. And at that time, I didn't know Mr. Richmond. I didn't know, because I would have just brought to Mr. Richmond. He helped me get some people who should have their gun license. He helped me with those. I haven't dealt with him in a while, but I didn't know him at the time.
And just for clarity, is that Bradford Richmond?
Yes, the one that, if anybody knows anything about gun permits, it was not Haley. It should have been Richmond.
And he was an attorney.
Yes,
That worked with the gun permit unit.
that's accurate.
Okay, tell us about the Myers case.
All right, so the Myers case and why that case was certainly a jury trial. So in this case, Jarvis Payton, so after Jarvis Payton got released from that case where I helped him out, he was with Miss Kimberly Myers. This is his friend. At the time, I think she was like 48, I think. But she's not, she has no criminal history for nothing. She's just a very nice woman, hardworking, have her gun license. She's not a criminal. So they were, I don't remember where they were. They were in Philadelphia. They got pulled over for, it was a minor traffic violation. And she gave the officer her license, her driving credentials. He seen the handle of her gun inside the glove box. And he, because she did not volunteer that she had a gun license, the officer panicked, Officer Ramito, and he dragged her out the car. He pointed a Glock pistol at her head, and she peed on herself. She urinated on herself, and she had a dress on. And he had her against the car for approximately 45 minutes. At some point, she said he put him inside the car. He put her inside the car. They did the same thing to Jarvis. But Jarvis rougher than, he's way rougher than, I ain't gonna call him a criminal, but he's rougher than, this lady's a woman, law abiding, but Jarvis is something else. But yeah, she was crying, she was sitting in piss, because when they put her in the car, she was sitting in piss, and she don't have no criminal history, no nothing. She thought the officer was gonna blow her brains out. Officer Ramito testified that he acted the way he did and was yelling gun, gun, gun because Mrs. Myers did not volunteer that she had a gun license. But Pennsylvania, under the Uniform Firearm Act, you only have to disclose your gun license if the officer make a request. Nobody ever asked them whether you had a license to carry a gun, and nobody reached for a gun. And if he's reaching, that's totally different, but that's not the allegations here. He just saw a gun, drew his Glock pistol, pointed at this woman's head, and she peed on herself. And they put her on the back of the car, so she was sitting in urine for like 45 minutes, approximately 45 minutes. And they wanted me to bring the case. And I said, yeah, we were seeking emotional distress damages, because at the time, so when I said earlier, one of these cases was really close to the limitations period. It could have been both of them actually, because I knew I had to act right away. So I just know what the clients told me, and I just put it in the complaint. Not every single detail, because the complaints are required to be concise, make a concise, short statement. They don't want long storybooks in their complaint. And I filed a complaint. And after the complaint was filed, and once discovery had started, discovery does start when you file a complaint in Pennsylvania, but the depositions and stuff like that, you wait to the scheduling board. As long as I preserved the time, so they didn't match the statute of limitations. That was the priority. The complaint is proper. There's nothing wrong with none of those complaints. Nobody ever said that. And
So
yeah.
So you talk about these complaints, you said there's nothing wrong with them. Did you file them properly to request a jury trial?
Yes, and that's why a jury trial was requested. Follow every procedure, not just the statutory law, but the procedure rules. Because they describe how, and what is it, 1007.1, and then you go on and they talk about how to properly file a complaint and what's supposed to be in there, and then you look at the case. It's very simple. It's not like you don't need a degree in rocket science. And I followed the rules.
So were the cases scheduled for jury trial?
Yes, and I paid the fees for both.
What happened after you filed your complaints?
Eventually we had case management conference.
On both cases or
Yeah.
separately? Or?
Yeah, so, all right, so this is how these cases were. Like, they were basically, the court could have just combined it. I mean, obviously, there's different dates of arrest and stuff like that between Miller and Myers and all of that, so I'm not saying they should have combined it. But the cases, the dates for everything was the same. That's why we had the joint case management conference. The court treated it procedurally like it's the same case. He filed it at the same time, 5 minutes after the other one. We're gonna treat it the same. So at the case management conference, we was there for both cases. And Mr. Hubbard, as he testified, well, I don't think he recalled whether they were together, but they were together.
Got it. And you said Mr. Hubbard was there. This is the same Mr. Hubbard that testified earlier, right?
Yes, Mr. Hubbard knew who I am.
Got it.
He knows exactly who I am, yes.
And you say you know exactly who you are going back to how long ago?
That O'Connor matter. He was there. He was at the hearing. I mean, obviously he testified to something else. He has a right to do that. And I don't know what's in his brain, but I know Mr. Hubbard. And I remember when he saw my face, he gave me a look like, yeah, that's just him. At the case man, it was like a reunion, a sad reunion. It was a terrible reunion.
What, if anything, did Mr. Hubbard say about the value of your cases at the case management conference?
What he told me with the O'Connor case, take a couple $1,000s. He told me that with the case. And but this was a little different here, because he actually, when we started case management conference, he said your client's cases aren't worth anything. I think you're exaggerating their injuries. What? How am I? So when you say I'm exaggerating the injuries, now that's a statement. That's a disrespect to me. I didn't show Mr. Hubbard any disrespect. And considering my history with them and how they lied on me, we ain't friends. But still, okay, let bygones be bygones. But I did not like how he approached me. He said, your client, you exaggerating your client's injury. Your clients ain't worth it. They ain't suffer no harm. And I didn't like that. The tone, he was not as pleasant and refined as he was here today. I'm not saying he was a barbarian, but he was not as friendly as he presented himself today.
With regard to his position on the value of the cases,
I
did
believe
he
that.
ask anything of the case management officer?
Yes.
What was that?
He said this is a motion case. The officers didn't do nothing wrong. They followed all the rules. And then I said, well, first of all, this is why we in court. We don't know who did what until a jury determines that, until we get some evidence. He just concluded my clients were lying and yours. Wait. I said, let's just go to trial. Because he was talking to me, and I ain't gonna say your clients.
The guy on the stand right now is the guy who's being disciplined by the Office of Disciplinary Counsel. He's a lawyer who has sued a lot of other lawyers and judges and police departments. And he has had sanctions against him by judges because of the motions that he files. So what happens is when he's on a case, if another lawyer files motions, he sues them. And a couple of his cases didn't turn out the way he wanted them to turn out. So he sued the judges, and he sued the police department. And he's claiming it's racist. So back in the early 90s, before he was a lawyer, he was illegally stopped, frisked, and arrested. He went pro se, and he sued the city for this, pro se, before he went to college, and he won 6 figures. So he became a lawyer, became a civil rights lawyer, and he's been making it hard on lawyers and judges and police departments. He's not all wrong. I mean, from what he says, I believe there's something to what he says, but he has not proven it. He has not come close to proving it. Today, he finally really talked about stuff that was wrong. This guy had a valid carry permit. he was they took it because they said he was an armed robber, but he never was an armed robber. Got it. But that has absolutely nothing to do with him, with his conduct. The judges keep not censure, that's not the word, not sanction, that's not the word. Something. The judges keep, telling him, reprimanding him that he's wrong. He can't do this. And he keeps appealing and he loses appeals and so that's who's on the stand right now. It's a big ball of mess.
First of all, we don't even know what really happened yet. We have an idea based on what our clients is telling us, but we haven't even done any depositions or discovery either way. So how are you going to say at a case management conference that your clients are totally innocent and my clients are lying, and then the personal attack on me? I'm exaggerating their injuries. Oh, so I'm just supposed to file a lawsuit and just agree with everything the city said? I'm a civil rights lawyer. I'm defending the plaintiff, and you have your role. I don't take it personal though, because I think he's a good lawyer. You have to defend your client's interests. That's good. He's very smart. He'd be stupid if he said, I'm going to give you whatever you want. So I expect him to oppose me. That's his job. But to make the personal attacks and say that I'm misstating the value of the case and the implications, calling me a liar, that was offensive. So we started off bad. And so to me, in my mind, and what I know, it's just a continuation from the court. You wanted me to take personally. You wanted me to take a couple $1,000 on a case where I won $100,000, more than $100,000 for emotional distress. Ms. Myers' case is way better than mine. And then forget the subjective, what happened to me. The law is very clear. The jury's supposed to determine this.
So I'm gonna ask a question. Who was the case management officer?
It was Mr. Orbick, Eric Orbick.
Who is he?
That's Hubbard's. Look, right. I don't know what's in his mind, but every time I see Orbick, after that, he was with Hubbard, and I know he got a job with the law department. I don't know what particular division of the law department, because it has divisions. They got a civil rights unit, and then they got other units. But after this conference, he got a job with the law department, and then thereafter I did see him a couple times crossing Market Street with Hubbard. And every time I actually was close to him, we never exchanged words, but his attitude was really nasty towards me after that case management conference. Mr. Orbick, and it took me his conduct towards me at the case management, he was neutral. But after Judge Anders entered the order with the arbitration, and every time I seen him, he gave me really dirty looks. And to me, it was like, wait. At the hearing, he was friendly, but after that, it was like he gave me looks that, when you have a really negative experience with somebody, you see them again. And I was wondering why he was looking at me like that. And anyways, he got a job with the law department, and every time I seen him after that, outside the courthouse, he was with, I only saw him actually like two times with Hubbard actually. They was walking somewhere. Because I see Hubbard and Jenner, they always walking back and forth across Market Street. It's some place they go for lunch or something like that. And it's just normal stuff. But his attitude towards me at the case management conference was really, when I see him in the courthouse, he was just kind of eye-rolling. Like, why? Anyways, I said what I said.
What happened after the case management conference? How were the cases scheduled?
So I think before we left the courthouse, the court automatically scheduled jury trials in both cases. And it came to my ECF electronically, and they were minutes apart, I guess, because the cases were case managed together, and the whole case, everything was on it. We had the same dates for it. It was a jury trial, as we requested, because we complied with the rule. The complaint was proper. We paid $600 for both complaints. Now, if we paid $300 to initiate the case, then that would go to arbitration, even if you asked for it. Because you got to pay for the jury. That's an extra $300. I mean, I know it's not a lot of money, but I'm saying we complied with every statutory requirement for a jury trial, and the court gave it to us.
Got it. So the court gave it, who taking it away?
The courts do whatever they want. Yeah, the courts. Absolutely. The court took it away. All right, so it was sometime after both cases were
sometime after the original scheduling orders in both cases. Later on, I don't remember the date. I don't remember.
Well, I'm not asking for the date.
I'm sorry.
Who?
Judge Anders. Judge Anders.
Okay.
Yeah, that's right. So he determined that the value of the client's cases were not, they did not meet the requirement for jury trials for Peyton, Miller, and Myers, and they all had separate injuries. And if you read the complaint, I properly comply with the law on what's required to state your claim for relief in order to trigger the right to have a jury trial.
So, how did Judge Anders reach this determination?
That was the mystery. Even the Commonwealth Court at the oral arguments asked that. Nobody knew. Today, this week, when Ms. Ammons presented her case with this case management form, that's the first time anybody ever mentioned that. Nobody ever mentioned that before. In the case with the Commonwealth Court, and even Judge Widget, he was like, why did he put the case in arbitration anyway? And he asked him, is there anything wrong with his complaint? You're looking at the complaint, like, what's the... Nobody knew. The Commonwealth, the city didn't even, well, he has discretion. Okay, but is anything wrong with his complaint? No, but Judge Anders has discretion. And that's all they argue.
Did you have a pretrial conference with Judge Anders before you made this determination?
No, and to me, considering, and I'm not going to belabor, we talked about it ad nauseum about the Jarvis situation, but that's what caused me to think something was not right. Because if you look at Rule 1021, because he cited Rule 1021, but he didn't comply with the procedure in there. So if agent, I'm sorry, go ahead.
Right there, can you go to Exhibit 38, please? Page number 696.
What number?
696.
I am at 696.
Got it. And that's Exhibit 38, Ms. Anders. You just mentioned Rule 1021. What is this?
So this is the civil rule that describes how you list your claims for relief in your complaint. Like for instance, you can't. So all right. So in rule, if you look at Section C, it talks about how you can trigger arbitration, or how you can take a case out of arbitration. It's up to the plaintiff. And when you file a complaint in Pennsylvania, you have to explain whether arbitration is appropriate. And when you do that, according to Section C of 1021, you got to state in the complaint whether the amount you're seeking is in excess of the arbitration limits. If you don't fill that, if you don't, because you don't have to say you want any type of damages in Pennsylvania. You can initiate a lawsuit with a written summons. You don't actually have to even say anything. You don't just have to file a complaint. So this rule says, all right, if your case ain't going to arbitration, you got to tell us whether it is in excess of a certain amount. And in this case, because Philadelphia is a city of the first class, the amount is $50,000. And I did that. Now, if I did not do that, that's different. Then the judge could have activated 1021D, and he could have determined, or he or she, whatever the judge is, because we don't know where we're going to put this case. But I satisfied the jurisdictional requirements by listing the amount in the complaint. And Judge Anders, in his 1021 rule, it says, let me see, 1020, yeah, he put it on his own, but without any discovery, pretrial conference, anything or otherwise.
So when you say you relied on 1021, can you read paragraph C?
All right, yes. All right, and counties having rules governing compulsory I did it again, right? I'm sorry. I'll go slow. In counties having rules governing compulsory arbitration, the plaintiff shall state whether the amount claimed does or does not exceed the jurisdictional amount requiring arbitration referral by local rule.
Right, and
Monica, thank you so much for the gifted memberships. Thank you, thank you.
then, you said earlier that is the plaintiff that governs, arbitration. Is this what you were relying on to make that statement?
Yeah, can I correct you a little bit? I'm not
Sure.
trying to be, you said the plaintiff governs arbitration
Governs
or the complaint? I think you said the, I know, I'm sorry too.
The plaintiff,
Okay.
the plaintiff, determines whether or not the claim should be in arbitration.
Yes, through your complaint, you gotta understand how the courts look at the complaints. It's the ad danum clause that governs all of that. And that's been Pennsylvania laws for a long time. Even the federal courts are the same. The jurisdiction of the court is determined by what's in your complaint. And there's case law on that. Baker versus Carter, 1931, and Exet, and a bunch of other cases. That's always been a rule. I never heard of a case management controlling a complaint in my life, in no jurisdiction.
So, the judge said that he made his determination based off of the same rule that you're citing now, right, 1021?
A provision of the rule.
So-
Yes, he cited,
Different paragraph?
yeah, he different period did. Yeah, but he didn't apply D. If he would have applied, see that's what caused a lot of suspicion though. That's the problem here. And I was trying to be very objective. And it just, even if you disagree, look, you don't file a motion to recuse just because you disagree with the judge. No, clearly the judge is the boss. I know that. It was a flagrant, like, you cited the rule, but you didn't even apply it. And otherwise does not mean subjective. You can't do anything subjectively. Even as a lawyer, when you file the motion, you can't say, I'm going to misinterpret this case, subjectively misinterpret this case, and ask the court for relief. The judge is going to chop your head off, and rightfully so. You're supposed to have an objective with the O, understanding of what the law says.
Do you have case law that proves that judges are required to examine the complaint and not the case conference memos? So, let me back up. Are you saying that the judge accurately applied, Rule 1021?
You're talking about Judge Andrews.
Judge Andrews.
And, yeah.
So he used this rule to justify, the amount of controversy for your cases.
That's what he cited, yes, and it was totally wrong. Like, it's not just a regular legal error. It's like he testified to what I already knew. His testimony just confirmed it. He said he made a subjective ruling. He looked at the case. He didn't even look at the complaint. He looked at the case management memo and knew that the opposing party went to arbitration, and that was it. Like, this rule is objective. That's why they say discovery, pretrial conference, or otherwise. They're giving the court options to make a objective, not subjective, an objective determination. That never even happened. And then arguably, since we argue in Section C, since we comply with Section C, and I understand the arbitration statute, he didn't even have jurisdiction to touch it at that point once it went up to the major trials. Even if he tried to redo that, it was already up. But still, forget that. Forget the nitpicking. If Judge Andrews said, look, plaintiffs, issued a rule to call show cause. Can y'all just explain to me why you think this case should be in arbitration? None of that happened. It wasn't even an appearance of trying to be objective. It was just this. All I know is the city wants this case in arbitration. It goes in arbitration. None of you people who got Glock pistols pointed to your skulls are going to have, or your injuries is not worth a jury trial. That's how it comes across. And if you read the complaints are well written. I didn't just write these things on the back of a cereal box and just mail it to the court. He didn't
ChatGPT helped.
even review that. But I knew that. I don't know what he did.
but it's just the appearance of it. How are you determining the value of a case without evidence about the case? It's like walking doing a preliminary hearing and the prosecutor saying, hey judge, we should have prelim. I think the defendant's guilty. Okay, boom, no prelim for you. Like, that's insane.
So, when you make this claim, do you have case law that proves that judges are required to examine the complaint and not the case management memos?
Yes, that and the arbitration. Yes.
I'm gonna ask you to look at Exhibit 42, starting on page number 704.
I'm there.
On page 705, can you tell me what that document is?
Okay, this is the Hall versus Reed case.
Now, is this case, is this one of the cases that you said you relied upon to interpret the arbitration statute?
I read this case.
Okay. Here we have a possibility, guys. Okay, the Hall versus Reed case. Okay. Here's why. Oh, I'm trying to remember. He has so many lawsuits. I'm trying to remember which one it was. The judge starts with the W, but I don't remember what her name is. Okay. Wilson, Watson, whatchamacallit. There's a judge that he had a trial in front of or whatever, and there was some misinformation by the prosecution, and I can't remember what it is, doesn't matter. They corrected it, and he wanted sanctions or something, and even though it was completely wrong, his client was still found guilty or did not win the settlement or whatever. And he wanted it fixed. And the judge said that even though they were wrong, they were not going to fix it. Because fixing it would cause harm to something or another. Okay? All right? If you're not with me so far, just pretend you are, because that's as much information as I got from the last 3 days, whatever. Okay. In her opinion, her verdict of why she made the decision she made, Reed versus Hall. She quoted Reed versus Hall. And this is one of his biggest piece of evidence of why they're racist. Because they took one quote from Reed versus Hall, this judge, misquoted it, and used that case as their as a reason for her decision. However, there's a caveat here, a big freaking huge caveat. He is absolutely not allowed to question, talk about, reference why she made the decision she made, her thought process on the decision she made. So he's saying she made this decision because of retaliation against him and racism and things like that, and he is not allowed to discuss her decision process at all. So he just said Hall versus Reed. So I don't know how far he's going to be allowed to go with this. I don't know. I didn't see this, but this is proof. Like, this could be proof. This could get him in trouble. This could go either way right now. It could be really good or really bad for one of them, or nothing. So, all right. So we'll see. I can't remember her name. We're just going to say Watson, even though if you hear a different judge's name with a W, that's who he's talking about.
I relied on this. Did I give this case to Humbert? I know this case came up in the trial court. I'm familiar with Hall versus Reed, RHI versus I don't know the other name, Flynn versus Casa, and there's a bunch of other cases. I didn't put all. Let me see. This exhibit does not contain all the cases
But I reviewed the statute, and because when the order was issued with the 1021D, when Judge Anders issued that order, first of all, I knew what the statute was anyway before this. But after he entered the order, let me look at this rule, and I looked at the statute. I want to see how bad the ruling was. I knew it was bad.
Crap, I think I might be wrong. I didn't think I was wrong, but he just said it was Judge Anders, which is a completely different judge on a completely different case that he got in a lot of trouble for. But I didn't think Judge Anders. Okay, we're just gonna have to pay attention. I could have been wrong about the Judge W.
But I knew it was bad, but let me see how bad it is. And all the cases supported what I already knew, and the arbitration statute is jurisdictional. It's jurisdictional. So, anyways, yes, I found Hall versus Reed, and I found the cases that's in this section. Yeah. And none of these cases say the judges have the authority. In fact, this Hall versus Reed case, and the Commonwealth Court used this case. This case support everything I'm saying. So, lawyers in this case didn't go to arbitration. In fact, 2 lawyers agreed not to go, and it's a very short case. And they didn't go to arbitration, and the judge in this case, I think his name was McCohen, I don't know, but he was upset with the lawyers. And in this case, the Superior Court explained that we do not countenance the temerity of a lawyer to encourage clients or others not to go to arbitration. But that was arbiter dicta. That wasn't controlling anything. It was just the judges talking.
In case you don't remember, some of his problems started when he had a client and he decided not to go to arbitration with that client. Neither him nor his client showed up for arbitration. So the plaintiff won. All right, they got a default ruling, and now he wants to appeal that, or he did appeal it, and then he said that the judge was racist because the judge ruled without hearing his side. But it's because he didn't show up to arbitration. So he's talking about this case where 2 of the lawyers didn't show up for arbitration, but he just said it out loud. They agreed to this. It was a stipulation, and they said okay. They all agreed to it. Nobody agreed to him not showing up to arbitration in his client's case. Nobody.
And we know what arbiter dicta is. It's not the holding of the case. The holding in this case, however, is that the trial court didn't have the authority to compel arbitration in this matter. The client, they didn't have the authority. And the Commonwealth Court cited this case to support its ruling against me, but it failed to mention that its quote to Hall versus Reed, talking about the temerity of a lawyer and not going to arbitration. They didn't say in their opinion in this matter that was arbiter dicta. That wasn't the holding of the case. And it's totally different from my situation. I never encouraged anybody not to go to arbitration. Everybody's forgetting that. I gave my clients that option. I don't understand why my clients are not here if I'm being accused of.
He absolutely did. He absolutely did tell his clients not to go to arbitration. He gave them specific statutes of the law. He told us which statutes and laws he told to his clients. He said, you do not have to go to arbitration because of these laws. And if you don't go to arbitration, we can appeal this. And, we can get this, and done if you don't go to arbitration. So, as their lawyer told them to do, they did not go to arbitration. We absolutely told he's their lawyer.
Of forcing them, telling them they can't go to arbitration. My clients never said that. My clients are totally satisfied with me. They made their decision. They thought it was dumb to have to argue their case and request less than $50,000 when they wanted more than $100,000. And I gave my clients this case, I gave them RHI, I gave them the arbitration statute, we talked about it. They said, we're just going to have to appeal. So they were aware of these cases. All these cases support what I'm saying. They even got some non-published decisions everybody know. Talking about Robert RHI, the Robert Half International. The case law is so clear. And I have not found a case that say if a plaintiff is asking for more than $50,000, he gives up his right if he doesn't go to arbitration for less than $50,000. I have not found the case yet. I have not found the case. I even asked Hubbard, can he find the case? And the closest thing we can agree to is Hall versus Reed, but when you read the case, it supports what I'm saying. And that's the issue here. Now, if there was any case law that say if the judge subjectively decide that even if you're asking for more than $50,000, you have to go to arbitration and you give up your right to appeal. You can't even appeal de novo. I would have told my clients that. I would have gave them the case. And I would have told them, no, you know what, we're just going to go to arbitration and whatever happens, we're going to appeal anyway. But the law don't say that. And I'm not the only lawyer, as I said, who didn't go to arbitration. I know lawyers who that, but I'm not going to, I'm not going to go there. But I've seen it in practice, and you don't go, and they're okay. All right, we'll see you when you pay the extra fine to $300. And then you can have your jury trial. But in this case, I paid the $600 or whatever it was on both cases. So they made a rule for me. That's what I'm saying. And am I saying the courts are all correct? No, I am not saying that. I love the law, and I love the judges, and I love the court. I love the process. I spend more time with the law than I do people. So when my client's cases were put in arbitration without any hearing or even any attempt to a subjective understanding, to find out what the value is of the case prior to a trial, somebody should have asked for discovery, issue a rule to show cause. Why? It was none of that. So to me, it appeared that, and especially against, and I'm not going to talk about that Peyton, but that's in my mind. And Jarvis Payton is my client on this case. And his friend was Miss Myers. So he already, the well was already tainted in how they felt about Anders and what they thought was going on.
So can I ask you this? When these cases were put in arbitration, you did eventually file a motion to recuse Judge Anders?
That's when the motion was recused. My clients want me to file that. When he saw his name on the docket, I said, that's insane. I said, who cares about that other case? Jarvis, I'm telling you, he's going to mess the case up. I know he is. My dad was, man, look, the past is the past. Just because the judge make a ruling that you didn't agree with last time to get corrected, that don't mean he's going to be a bad judge on every case.
You need to slow down a little.
I'm sorry, I'm doing it again. But I had a discussion with Mr. Payton because he was encouraging me to file a motion to recuse just because he saw Judge Anders' name on the case. This is before the case management conference.
Just briefly, I wanted to turn your attention to Exhibit 45.
Mr. Duckett, I'm just noting that it's just about 3 o'clock. And so maybe before we go to the next exhibit, we should take a break and we should see if Judge Wallace is here. So that I want to make sure that we get her on and off.
That's the judge. That is 1,000% the judge I was talking about. That is 1,000% the judge that used that case, Reed versus Hall or Hall versus Reed. I can't remember now. In her ruling, that we're not allowed to talk about.
As possible, so that we can resume. Is this a good point to do that?
That sounds good.
Okay. We go off the live stream.
Yes, Sarah, please stop the live stream. Thank you.
So because we're not allowed to talk about it, they cut the live stream. So we didn't see what happened with the whole Reed versus Hall case. But we'll find out. I'm sure they're gonna talk about it without saying what the judge said.
Do you solemnly swear or affirm the testimony you're about to give will be the truth?
Okay, I changed my mind again. That's probably Judge Wallace right there. She showed up in person. She didn't even do WebEx, because that's her lawyer right there, isn't it? Isn't she the one in the blue? Sorry, the lawyer down on the bottom right in the green. Was she not the same lawyer? I think she had a ponytail and a blue jacket on day one. That's Judge Wallace's lawyer right there. So that must be Judge Wallace. And she cleared her calendar and she came to Philadelphia for this. She didn't even phone it in. She could have done Zoom. So I don't know what they were talking about just a minute ago when they went off the live stream. Now, They're not allowed to ask Judge Wallace why she came up with the decision she came up with. So the whole panel right there was like, are you sure you want to call Judge Wallace? Because we don't see any reason, any questions you could possibly ask Judge Wallace. If you're not going to ask Judge Wallace why she came up with the decision she came up with, which you are not allowed to do. So Judge Wallace is there, and we will see. Here's what I think, and I'm not sure. Here's what I think and why I would do exactly what they did. I would call Judge Wallace anyway, knowing I'm not allowed to ask her anything about anything. I'll tell you why. Bulldog. She's the one on the right in the middle. She's at her own little desk. So you have the girl in the green blazer. That's the judge's, who's the witness right now. That's her lawyer. The one beside her in the middle at her own desk. Where the heck is all her binders? I don't know. It doesn't matter. She's the bulldog. All right? She's the one. She is the counsel for the Office of Disciplinary Counsel. Okay? The ODC. I bet you she opens this door wide. I bet you she asks Judge Wallace a question that's going to allow Attorney Bell, or whatever his attorney's name is, which is escaping me right now, to ask whatever they want of Judge Wallace. I would do the same thing. Let's go. Let's see.
Before we begin, Judge Wallace, thank you very much for being with us today. We appreciate your time. And I wanted to let you know that there's already been a ruling that your testimony today is going to be very limited.
Okay.
And everyone understands what those limitations are. And I'm going to be ruling on any objections or if I believe that we have exceeded those limits. So with that, Mr. Duckett, you can
Thank you,
begin.
and good afternoon, Judge Wallace.
Good afternoon.
When did you become a judge with the Commonwealth Court?
Objection. Again, I apologize, but I really don't know what this relevance has to the testimony here today.
I'm assuming, Mr. Duckett, that this is going to be a very brief background for foundation. Is that right?
Okay.
I'll allow that question.
I was a bench in January of 2022.
So at the time of the cases here, Millers and Myers, that was the first year that you
The case with Millers and Myers was when Aaron Bell, the defendant, the one who's in trouble with the counsel right now, sued the lawyers for putting in simple motions.
took the bench?
I thought that the case was in 2023. But if you're telling me it was 2022, then
Up to that point, how many opinions had you written?
Again, objection. We're not here to discuss her judicial opinions and her judicial
I'm not
history.
asking about the deliberative process, just how many?
What's the relevance of that, Mr. Duckett?
The relevance ties to what she did after she wrote the opinion. So whether or not what she did after the opinion is consistent with what she did with the other opinions that she wrote.
Objection sustained.
If a lawyer comes before the Commonwealth Court and engages in misconduct, does the court have avenues to rein that lawyer in?
avenues?
Means,
Again, objection. We're not here to discuss how anything happens when someone is before her during her judicial duties. We are here for a very limited purpose. What happened after the fact? That is all.
I agree, Mr. Duckett, and that was my ruling. So
Right.
why don't you get to the facts of this case and ask her about that?
and I'm not, right now, I'm not asking about the deliberative process in this case. I'm asking in general what the Commonwealth would do if they encounter
No, Mr. Duckett, you don't get to ask about the Commonwealth Court's deliberative process in general. You get to ask about the facts of this case post-dating the opinion that was issued in this case.
outside of any deliberation, outside of any, so outside, all right, I'll move forward. Isn't it true that, you had the power and authority to hold a lawyer in contempt?
Again, objection.
Sustained. Mr. Duckett, you really should get to the permissible scope of testimony that we discussed.
All right, after your decision in this matter, you decided to file a complaint against Mr. Duckett. Now, in what form did you file that complaint?
I sent a letter.
And in that letter, what specific allegations did you make?
Oof, oof. So she started this. She sent a letter to this department complaining about him, and no one's allowed to see the letter. So he just asked her what was in the letter.
I think that the allegations were dealing with conduct unbecoming to an attorney and my concern about his intentional failure to act impacting his clients. And I had a concern that besides those clients being injured, that if it wasn't brought to his attention, that future people could be hurt as well.
Right. So when you said that his failure to attend arbitration, did you talk to his clients and see if they wanted to attend arbitration?
Again, objection.
That's objection.
Are you limiting your question,
To-
Mr. Duckett, to the period after the decision was issued?
Period after, and the nature of this letter, yes.
So the overruled, but only as to the period after the decision was issued. So the question was just, did you talk to the clients?
I never called the parties to the case.
And then the nature or the substance of this complaint, you said conduct unbecoming. Was this, any of this conduct in court pleading or in court procedures?
I have to object. This is sort of my concern with this whole line of questioning is Judge Wallace's only connection to this was sitting as a Commonwealth Court judge. Any information she took in was during that appeal, during that argument. And again, I just have to object to any line of questioning about the specific conduct here.
Mr. Bell, you now have a copy of the letter, and if you'd like to introduce that as an exhibit, we'll allow that, and then if you have questions about the letter, you can, but we know what the complaint was because we have the letter.
Right, I'd like to first mark this as exhibit 63, the respondent,
The letter?
the letter.
Any objection?
I have no objection.
Do you have a copy of your letter?
I don't have a copy.
May I?
And
I have extra copies.
you have an
I
extra
have
copy.
abundance of copies. Here you go, you can get this over.
It's crazy that she just said, I have extra copies, and he handed him an extra copy because she refused to just turn the letter over in discovery up to this day of trial for him. So she's the one that actually put this judge as a list of expected witnesses, but she never intended to call her. And no matter how much they asked for a copy of that damn letter, she refused to give it, saying that yes, this judge made a complaint about you, but I'm prosecuting you, not the judge. I decided your conduct was not okay, so I am bringing these charges up against you. It has nothing to do with what the judge said. Yeah, that's one piece of the information, but you don't need to know what's in the letter, because she's not the one that's doing this. We are doing the Office of Disciplinary Counsel. So this whole time, months and months and months and months and months and months and months, they don't get to see this letter. And because she put this judge on the witness list, these two said, bet, we'll call her. And then she's like, well, I put all judges on the witness list. That doesn't mean I'm going to call them. They're like, oh, no, we'll call her. We don't get to see the letter. We'll call her. She wrote the letter. So the panel made the judge come. Judge, yep, you put it on the witness list. She's coming. You have a letter you won't turn over? Fine. They don't need the letter. They'll call her. So now she's just like, oh, I have extra copies of the letter. Here you go. Take it. If she would have did that a year ago, that doesn't matter. It's too late.
Is this the letter that you prepared and sent to the ODC?
This is the letter.
Yeah. Now, you made reference to a number of statements that my client made in your letter, correct?
Yes.
Would you agree that none of those statements were made in any court pleadings or made in front of any judge?
Objection again. This is going towards what she considered in front of her in an appeal.
Sustained.
You would agree that this letter is absent of any mention of black people serving on the jury?
I have no idea what you're talking about with black people serving on the jury.
Right. You agree that that letter is absent of that claim?
Yeah.
Okay. Now, did you confer with anybody else on the panel after? I'm sorry.
Let's let him finish the question first, but then we'll hear any objection to it.
Did you confer with anybody else on the panel after you made your decision about filing a complaint against Mr. Bell?
Objection again. I find it very tricky to imagine that any conversation related to this information and the appeal and the facts of the case in front of them can be taken apart from that.
I have some information that could be helpful.
If you'd like to. Sorry.
So we'll overrule the objection and we'll hear the answer.
So it wasn't after I filed the complaint, but when we left the bench, a panel member who had been a past president judge and is currently a senior judge said, because you'll be authoring this opinion, I think it will fall on you to report this to the disciplinary board. So I share that with you as the impact it had on me as the listener. I already had my own concerns, but having heard this from a past president judge and a senior judge, it affirmed for me that my concerns were correct and that I had an obligation. It's like, I never wanted to hurt attorney Aaron. However, I had an obligation to report him.
Did you confer with Judge Anders about the conduct of
As
Mr.
far
Bell?
as I know, I've never talked to him in my entire life. Like perhaps I would have said hello in an elevator not knowing who he was, but to my knowledge, I've never talked to him about anything.
What about Mr. Hubbard?
I don't know who that is.
To your knowledge, did any other judge notify the ODC about Mr. Bell's conduct?
So
Again, objection. I don't know how her speculation on that is relevant here. She has a very limited purpose.
you're sustained.
How many, at this point in time, how many lawyers had you filed complaints?
Objection.
I'm not asking for names.
It doesn't matter. Objection.
That's outside the scope of what you can ask about, Mr. Duckett. Sustained.
I don't have anything further.
Okay, Ms. Hammond?
I don't have any questions.
Okay. Judge Wallace, again, thank you
Thank
very
you.
much. I appreciate it very much.
Oh, she ruined it. She doesn't have any questions. Oh my gosh. Oh, I was so excited. I was so excited for her to open that door wide up. Nothing. He got absolutely nothing from the judge. We don't even get to hear what's in the letter.
Your excuse.
Thank you.
Thank you, Judge Wallace.
Thank you.
However, we did get to take a letter, Maria. I haven't heard that song in so long. I forgot about it. And I'm glad that we got that.
Let's take a 10-minute break. Okay. Mr. Duckett, before we resume, can we just do a little logistical planning here? So we've got a little less than an hour left for today. And is it your expectation that your direct examination is going to continue past that?
No,
Okay. And then, we have any other witnesses?
no.
Okay. So, why don't you proceed?
Thank you. Mr. Bell, we left off asking you about a motion to recuse Judge Anders. Can you go to Exhibit 45?
Is it 45 minutes
And that's page number 760.
up there?
What is that?
This appears to be a motion to recuse that I filed in the Anthony Miller case. And I think it's two of them here, and this is a motion to recuse, but it appears to be that there's more than one here. I think there's one on the Myers case too. Yes.
And what was the basis for you? I know we broke our examination, but what was the basis for this recusal? A motion for recusal?
Yeah, well, just as I said yesterday, just the appearance of bias. I wasn't saying like Judge Anders is actually biased. I wasn't trying to say that because you never know what people actually are. Just based on, as I testified previously, based on information I had in front of me, and I believe that it appeared, especially the ruling on the case, making a ruling on the case, it's just the deviation of law. That to me, that showed appearance of bias. He made a subjective ruling on like someone's injuries without even hearing from the witness, and like he didn't determine whether they were credible. He didn't determine whether they were believable, which is same thing as credible. He just made a ruling based on paper, and I just thought that was fundamentally unfair. There was no rule to show cause. Why? If he thought anything was wrong with my complaint or anything's wrong, there wasn't any of that. It was just a decision based on what I knew at the time is that Hubbard wanted the case to be arbitrated. So it appeared that it was just a very one-sided ruling.
Now you made a statement that that ruling didn't seem like it complied with the law. Can you go to Exhibit 39, which is page number 698?
I'm there. That's 698.
All right, what is this document?
698 is the arbitration statute. And it outlines like the limitations of what the court can put in arbitration. And it sets forth the rules of the road for arbitration. And Section A, it pretty much says that, the judges could put whatever they want in arbitration. And then it has an exception, it's limitations in Section B. It said no matter, shall be put in arbitration. Real estate cases, in cases where the plaintiff is asking for more than $50,000. And in Section A, the legislature here specifically referred to local rules versus rules. Let me see. Yeah, it says local rule, general or rules. So through the general rules, or rules of court, a judge could put a case in, or he could refer.
Well, guys, I have to go pick up my son from work. I have to. So I'm going to bring Tiffany in here, even though she's in the middle of a video game with my daughter. She's going to be so mad. Be nice to her. She's not pleasant. But I should be back before this ends. I know this next favor I have from you is going to be really hard. I know this. I have not seen this part yet. I have been dying to know if he presents any evidence that he has been targeted due to his race, that there's a conspiracy theory on him, that any of the cases that he lost due to judicial misconduct or even misconduct of the other lawyers. I'm waiting for any sliver of evidence, which he has not given us yet. So I'm going to put it on my phone, but I'm going to drive in and picking up my son. If you notice, nothing. Josh, I have nothing but bitterness and resentment. I'll give you either of those. You know what I'll do, Josh? Just for you. I'll throw in a great ass chewing. I will swear at you or yell at you. I will make you feel this little. But just hear me out. Hear me out. I'll make you feel this little. That way, when you go home, and nobody treats you like that, you will feel so happy. You will feel so happy in your house. I was on this guy's side. I was so on this guy's side. I wanted him to produce something. And he broke my heart. But if he unbreaks it while I'm gone, which, makes sense, someone I need to make me happy, unbreaks my heart way out of my sight where I don't get to see it. But if you see it, you can tell me when I get back. You don't even have to remember what it is. You can just say, you missed it. He did present evidence. And I'll go watch it myself. I really will. All right. I'm going to go get my son. I'm going to get my daughter to come in here. This is for 36 minutes and 44 more seconds. That's how long this live stream is if I don't pause it and talk. So I should be back by then if my son is ready. But if my son makes me sit there and wait for him, I'm just going to leave him there and he can walk home. I'll be right back, guys.
A case of arbitration, except in Part B, it's a limitation. You can't put a real estate case in arbitration. And in cases where the plaintiff properly requests for more than $52,000.
Got it. Can you look at Exhibit 40, page 700?
I'm here.
All right. What's this document?
So this is the arbitration statute. Because the arbitration statute explains like how you could do stuff. This is talking about like if there's a prior agreement to arbitrate, that's the exception to the rule. To the rule that a judge cannot put a case in arbitration. Because if you have an agreement with someone to arbitrate the matter, like if you like buy like a laptop or something and there's that arbitration agreement, they can enforce that. Because there's and they talk about that in that rule.
All right, can you go to Exhibit 41, and that's page number 702.
All right.
What's this exhibit?
Oh yeah. So if you want to compel arbitration, you talk about like it's similar to 7303. So if a judge is going to determine whether to put the case in arbitration, it's just like an agreement. The judge don't look at the merits. The judge just he doesn't look at the merits of the underlying case. He just look at the agreement, and the judge can force arbitration if there's an actual agreement.
And then we already talked about Exhibit 42. With regard to, now Exhibit 42 is page number 704.
All right, I'm here.
And essentially, so Exhibit 42 is the case law that you use to support your position?
Well, this is some of the case law that I consulted about the arbitration statute. And that, like, I was already familiar with some of the stuff. So when I was looking at, like, when the judge made his ruling, like, this was, I had this knowledge. And I shared this with my clients. And in addition to that, the prior incident with Peyton, like, all of this is on my mind. In addition to this, the Peyton incident, I know how the situation with Prater, how that leading a little bit. It was how she entered that ruling. Like, all of this is not objectively. I'm looking at all of this, and I'm not looking at it in a vacuum, because I remember Hubbard was on that Prater case. I have this law here saying the judge can't put the case in arbitration. I had a situation with Jarvis Payton and Hubbard, and it appeared to be that the judge was just ruling in favor of the city, just because. I've seen Judge Prater did that in that order when she entered the crime fraud against me, when I didn't ask somebody to commit no crime. So, and I know the reputation of the Philadelphia Court of Common Pleas. I'm not trying to disparage any of the honorable members of the bench. I'm not going there with that. But when I filed this motion, I'm not trying to attack the judge. It's just and I'm not trying to be subjective, because subjective is personal. I'm not trying to be subjective. It's objectively what I know about the courts, what appeared to me how they used their connections with Judge Prater to enter that crime fraud ruling on that other case. And that was only like 2 years before. Well, it wasn't even 2 years actually, when she entered that order. Yeah, it was closer in time. I remember that, because the Payton hearing was in 2017, and the false statement was after that, like in November 2017. So I'm putting all this together when I filed the motion. So that's on my mind.
When you said you considered the reputation of the court, can you go to Exhibit 60, please? Page number 1022.
Yeah, 1022. I'm at 1022. Wait, I'm sorry. I'm sorry. I'm there now. Yes.
I do want to raise an objection to this, a standing objection to any testimony in regards to numbers, to exhibit numbers 60. First of all, Mr. Bell did not put this in his motion to recuse anything in regards to the First Judicial District of Pennsylvania's equity organization assessment. The second reason why I'm raising an objection, because Judge Anders is not mentioned in this report at all. I don't even know when this report was compiled. I'm trying to find a date on this. I don't remember seeing a date on this.
First page.
I'm sorry?
First page.
Wait, let me,
Mr. Duncan,
this is
you're gonna ask the witness
2019.
when he first saw this report?
Yes.
Okay, so let's hear the answer to
Okay.
that question, and then we'll consider your objection.
Mr. Bell, what is Exhibit 60?
This is the First Judicial's the equity report, where he talked about issues with discrimination within the court.
When did you first see this?
I seen it when it first came out.
Was that prior to you filing your motion for recusal?
I don't recall the exact date. I know this was around, I don't recall the exact date. I know this was in 2019.
When was the motion to recuse?
Page 760.
If you can look back at Exhibit 45, page number 760.
June 11th, 2020. Right, Mr. Bell?
If it says that, yeah, I'm not disputing.
So is it your testimony that you saw this report, that's Exhibit 60, sometime between July 2019 and June 2020? You had seen it before you filed this?
If the dates match up, because I remember when this came out, and it happened a long time ago, because we were all talking about it. I remember this report. Yeah, I remember this report, absolutely, because me, Mr. Burt, everybody was talking about it.
So my question, Mr. Bell, is, had you seen this report before you filed your motion to recuse on June 11th, 2020?
I believe that's accurate.
Okay, and the objection's overruled.
Okay?
Now, did you ever accuse Judge Anders in your motion for recusal? Did you ever accuse him of actual bias?
Not that I recall, because I think that would have been crossing the line. And I don't know I don't know what's going on in his mind. Actual bias, you would need way more advisors to file a motion based on actual bias, because I don't know. I just judge him based on his conduct and what I've seen and I can prove happened. So I was trying to be very careful, and I wasn't just saying the appearance just to make pop shots at the judge and hide behind the language. No, I'm just trying to be honest. I don't know if he's actually biased. Just based on the appearance. And then what I know about the Philadelphia courts. And I want to be very clear. I'm not trying to disparage members of I know this is a difficult situation, but I'm not saying all the judges. I'm not saying that. I want that to be super clear. And I'm not even saying Anders actually. I just said it appeared based on what I had in front of him. I don't even know Anders. So I hope that's clear.
I'll move on. Did you attend the arbitration proceedings in Miller's and Myers case?
As I answered yesterday, I did not. My clients did not want to attend. They thought it was ridiculous.
As a lawyer, are you allowed to force your clients to do things they don't want to do?
No, I can't. You can lose your license like that. I just gave them the information that I had. And I let them make it. I told them to make a choice. When Judge Anders determined the value of their cases without a hearing or any evidence, we had to talk about it. And the clients thought, even if we went to a jury trial and won, because he already predetermined the case, he's going to take the verdict back. The judges can do that. They can grant a remittitor. You could just throw the whole judgment out. You're going to appeal anyway. They're right. And we was going to appeal anyway. And I told the clients, if we prejudge the case, if we win, we're probably going to just say, yeah, this case ain't worth nothing. I already ruled that because he predetermined it. And that's why you don't predetermine the case.
Did you have a court order excusing you from arbitration?
Yes, I did. For Miller, I had a court order. I didn't even have to go.
And that came in what form?
Wait, what? I'm
You
sorry.
said, I asked you, did you have a court order excusing you from arbitration?
On the Miller case, yes.
Right. What judge?
It was Judge Patrick.
And that came after the cases were already put in arbitration?
Yeah, I mean, I'm not trying to be smart, but yeah, it would have to be, yes, because that's why we filed a motion to ask the judge to take it out, and she granted it, yes. The city didn't contest it at all.
What happened after your clients refused to arbitrate their cases for less than $50,000?
It went to, the trial division, I forgot which one, and the judge entered a no pros. And then, the court gave instructions that if you wanted to contest the no pros, you had to file the 1051 motion. And, we filed the 1051 motion, excuse me, 51 motion, not 10. And in order to get relief on that, you have to show that your motion to open the judgment was timely. You had to show that you had a reasonable basis to, for whatever your failure to attend arbitration was. You gotta give some basis that makes sense. And then 3, the judge looks at the merit of your complaint to see if your complaint is even worthy of the court's time, additional time. And
So, Mr. Bell, can you turn to Exhibit 47, and that's bank number 806.
I'm at 86.
Okay, what is this document?
Oh, this appears to be the motion for relief from the non-pros, and where we explained to the court that when I filed this right away in both cases after I received the order of the default. So we met the timeliness requirement, and we argued to the court that we had a reasonable basis to open the judgment and schedule a trial because my clients are asking for more money than what the arbitration program can legally give, and that it was a jury trial case. And the court responded and denied the motion. And the court agreed that the petition was timely. The case had merit, they said that, but they said I didn't have a reasonable basis for not going to arbitration. And I think in this motion, I haven't read it in a while, I know what I filed, but I think I mentioned that like my clients didn't want to go because they didn't want to litigate for less than what they were asking for. They didn't think it made sense, especially what I told them about the law. And then also ethically, I know the court was saying, I know there's an order saying, okay, go to arbitration, but I could not legally, in my opinion anyway, I didn't want to make a frivolous, ridiculous argument to the arbitration panel and ask them to violate the law or try to challenge the law and ask them to give more money what legally they can give. It didn't make sense. And I didn't want to present a frivolous case. My clients thought it was just ridiculous. They did not want to go at all. And anyways, I filed 2 of these motions, the Miller and Myers. I think these are probably contain both of them.
Were those motions granted?
No,
Okay, so what did you do next?
appeal.
You appeal. Can you go to Exhibit 48, page number 865?
I'm there.
What's that document?
This is the statement of matters contained on appeal in 2 cases, in both the Miller and Myers cases, and I explained the issues. And I also, in part 3, I talk about what I found out about the brother in the pending lawsuit. So I must have argued that, in order to put it in the 1925, that was preserved. The issue with the brother was preserved in a 3051 motion. And again, I don't remember when exactly I found out about the pending discrimination case with the brother. But I know that I wanted to preserve it. I talked to the clients, they wanted to preserve that, because I keep them updated on stuff, and they thought, you gotta argue that on the appeal, you gotta argue. I said, I'll preserve it. I don't know if we're gonna argue it, because the meat and the potatoes here was the plain language of the arbitration statute, and like cases like RHI, and all the other cases interpreting the arbitration statute. I thought that was like, it was kind of an easy win on that one. So I put the brother in there, and I think I attached a copy of the lawsuit in the motion. I wasn't just saying his brother in the lawsuit. My clients would potentially argue that on appeal, but I didn't even argue that issue on appeal. I didn't argue motion to recuse on appeal. We were going to argue, Jarvis wanted me to argue that on appeal.
Yeah, he said, you better argue motion recused because of the case, and he was biased, but I didn't really want to go there. Plus, like, I didn't want to keep bringing up that, I hate talking about that case. Like, I'm gonna moved on, so I was focused, I'm sorry.
I just want, you mentioned the brother multiple times. Whose brother are you talking about?
I'm talking about the case with the racial discrimination case with, Judge Andrews' brother. I didn't make that case up. I found that in the book. Well, I printed it after I confirmed it was real from the ECF.
Now, did you subsequently file briefs in these appeals?
Yes, we
You
did.
put an example 49? And that's brief number 870?
I'm there. Just
And what are those documents?
it starts at so these are my briefs. They would have been both the brief and Miller and Myers together. I put but they was filed together. Everything was done together. And there's an appellate reply. There's an appellate main brief, opening brief, reply brief for both cases, and I'm sorry, I'm tired. Communicate to the Commonwealth Court the arbitration statute, the case law, I spell it out. Didn't even argue anything about the motion of recusals on the appellate level because I didn't think it was necessary. We could rely on just the plain language of the statute, 7361, and also the Hall versus Reeve case, because if you look at the Commonwealth's opinion, the Commonwealth Court's opinion, they rely heavily on it. They relied on that dicta from the Superior Court, and where it said we don't condone the temerity of a lawyer. But I didn't encourage nobody to go to arbitration. I don't understand why that's keep mentioned. I told my clients not to go. Nobody ever heard from my clients. My clients did not want to do that.
Now you mentioned, I'm sorry, did you?
And also, if you agree, I know it's a lot of reading too. There's a lot of words you should understand. But Hall versus Reeve does not stand for the proposition that the Commonwealth Court cited. And to me, that is very scary and troubling. It does not say that.
So with that, can you go to exhibits 51 and 50, I'm sorry, 51, 956 base number, as well as now if you look at exhibit 52, 965. What are those two exhibits?
Hold on, you said a lot there.
956
956?
and 965.
Alright. 956. So exhibit 51, 956. This is the opinion that Judge Wallace wrote, and Miller versus Coulter, and I'm sorry, what was the other page?
965.
That's 65 is. All right, so this is both Miller. This is both the Myers and Miller opinions that Judge Wallace wrote, and these opinions. So it was the same argument basically in both cases. The only thing that's really different is just the factual backdrop of the cases, but the legal rulings and everything is the same. It was decided at the same time. It was the same issue, and in these opinions, the judge. There's no evidence in there. There's no opinion. They don't provide any opinion that support the proposition that my clients had to first arbitrate their case for less than $50,000 in order to have a trial. And they cite Hall, the court cites Hall versus Reeve in there, but Hall versus Reeve doesn't support the contention that the court is citing it for. They don't explain this opinion, the paragraph before and after the quote where they say the temerity of a lawyer and not going to arbitration. If you read those opinions, it is very misleading. It makes it appear as though the law was clearly established that in order to have a trial, you had to first litigate your case for less than $50,000 and then have a trial. if you compare Hall, and they cited Hall versus Reed because it was very critical of the lawyers for not attending arbitration. So that was cited in there. But it does not say the whole story, because the criticism of the lawyer for not going to arbitration in Hall versus Reed, it was not the holding, it was just the dicta. If you read the paragraph before and after, it's very clear that first, I'm not the only lawyer that didn't go to arbitration, and that the court did not have the authority to say that people could not have a trial for not going to arbitration.
You keep mentioning that Hall v. Reed case. Can you go back to Exhibit 42, number 704?
You said 704?
Yes.
All right, I'm there.
Now, is that the Hall v. Reed case that you're talking about?
Yes, this is the Hall v. Reed case.
Just briefly, can you go to the ruling on that case?
All right. The ruling is, it would be like the last.
Actually, I'm sorry, you said that the court quoted Hall v. Reed.
Yes, the
And then you said the sentence after was omitted. Can you read the part that the court cited and the part that was omitted?
Yes, it's on page 706, the last paragraph where it started at "we do not," and start there.
Yes.
You want me to read like all of this, or you want me to stop?
I want you to read the part that the court quoted and then the part that they omitted.
All right, so it says, and I'm gonna read it slow. "We do not, under any circumstances, countenance the temerity of any member of the bar who instructs or encourages a party to intentionally fail to appear at a scheduled arbitration hearing so as to exercise an automatic right to appeal the arbitrator's award to the court of common pleas for trial de novo." And I don't have her opinion in front of me, Judge Wallace's, but I think this is what she's, I think that's all she cited. But after that, her opinion fails to include the rest of it, where it says, let me see, where is that? Down on the next paragraph at 706, say, "Nevertheless, we conclude that the Halls comply with all necessary steps in perfecting their appeal, and that Judge McGowan erred in quashing their appeals for trial de novo." They did, the Commonwealth Court failed to put that on there, but then they failed to put the paragraph above the paragraph where it says "we do not countenance." Still on page 706, on the left side, the second paragraph from the end where it says "a problem." The Superior Court said, a problem frequently encountered in present practice is the failure of a party to appear at the hearing. Present practice does not permit a non-suit of a non-appearing plaintiff," and then they just talk about that. But when she reads her opinion, the opinion as written in the Myers and Miller cases, it appears that like I'm the only lawyer that didn't go to arbitration, and it doesn't provide the proper context. In this case, in our case, it's actually a little different than this, because here, the lawyers on this case, they actually told the court that they agreed not to go. That was the agreement between both the lawyers. If you read up a little more, this case ain't nothing like that. I didn't encourage nobody. I just gave my clients a choice. That's what my clients do. My client ain't complaining against me, but this case is nothing. I didn't encourage nobody, a lawyer or nothing. I didn't do none of that. So this case is an opposite from our situation for just that alone. But how it was quoted in the opinion and citing this case like it was some type of conclusive authority that showed that I should have did my research and knew what I was talking about is totally misleading.
So do you think the judge's ruling was fair?
I don't think so.
And why not? I mean, outside of what you stated, was there any other reason why?
Well,
Yeah, just, the complaint afterwards and the misstating of this case. And now I found out today, I didn't know, I thought Judge Wallace was complaining about me telling Hubbard in an email. That was an email. Me and Hubbard was going back and forth about the case. And to be clear, the black people on the jury, that was a little personal dig at Hubbard. Because on that case, I had a case where they, they struck all the black people and they were braggadocious about it. Not obviously the court, but I mean, they strike a lot of black people. This case was in the city of Philadelphia for a reason, just for the more diverse jury. Because you bring a case to the Eastern District, you want to get a real conservative jury, which could be a good thing. But in this particular case, I wanted to test off the Philly jury because people in Philadelphia, especially these government cases are very hard, man. And so you gotta think not only just filing a complaint, but where you're going to bring the complaint, depending on the identity of the parties and the issues. So, they couldn't just strike all the black people off the jury. So that was a little dig. Plus, I was aware of the $10 million lawsuit that they lost a year before where Hubbard was on it. And I know he had a stacked jury. Somebody was there and they told me. So I was trying to be a little smart when I said that. But I'm not saying that we were only going to have a jury of black people. Come on, I know that's not possible. And I'm not trying to strike the white people. I just said that because I know in my case, they strike all the black people. There's always a reason for that. But I just want that to be in context, man. But anyways, to answer your question, I thought Judge Wallace wrote that she was complaining about my email to where I was kind of taunting Hubbard about the black jury. I didn't know that she would write that to today.
So can you go to exhibit 53, that's bait number 976.
Yes, this is the complaint that was filed against me, or this is the DB7, and it says that it was the complaint of Judge Stacey Wallace. It didn't say that ODC, like how this is written right here. It made it appear that Judge Wallace was complaining about me for making that statement and everything. It didn't say that ODC. It didn't say this was ODC's complaint. It just said Judge Wallace is the complainant.
Now, when you say it just says Judge Wallace is a complainant, have you ever had a complaint against you that had more than one complainant? Or more than one person bringing a complaint?
Yeah, that was the other matter that we talked about earlier.
And can you go to exhibit 56, page number 1006?
I'm at 10-6.
And this is a continuing objection. He already testified to it, but continuing objection that this is irrelevant. This matter.
Just trying to recall what we said about this before.
Oh, he testified to it.
Yeah, he did. He did. You can proceed, Mr. Ryder.
Thank you. I just wanna, just on that, who filed that complaint against you?
Judge Schulman and Nicholas.
So,
This complaint is false.
right, but there was two people joined in that complaint?
Yeah, this was because I brought a civil rights case, and he wanted me to withdraw it. I wasn't going to abandon my client. It was a tough case, but I'm not going to abandon my client. He trusted me to fight for him, and I was going to do that. Cummings wanted me to withdraw the case, and I said, no, absolutely not. He was threatening my law license and everything like that. This complaint is completely false.
Okay, I want you to look at, what's now marked exhibit 63. It's up there on the table. to your left. Exhibit, 63, what is that?
It concerns a different, wait a minute, it's been a long day.
I'm not asking about the last exhibit, just 63 now.
All right, this concerns a separate matter, the matter we talked about earlier, the Meyer Miller. Yeah, because they had Wallace on there. Yeah, it's a different case, different case. Wallace, this Wallace complaint.
Right. And I want you to compare, exhibit 63 with exhibit 53, 63 and 53. Now, exhibit 53 is base number, 976.
All right, I'm here.
Now, exhibit 53, the complainant is who? The complaint is coming from who?
It says the Honorable Stacey Wallace submitted this, so I assume that she
will be
did.
how it goes.
Right, and part of that complaint.
I can't help any of you. If my daughter bans you like that, look, I gotta go with it.
Talks about black people serving on the jury.
Yeah, so I thought the appellate judge was trying to get me disbarred for saying black people served on the jury when I got this. I hit the floor when I seen this. I literally almost fell. In fact, no, I remember I was driving. I checked this in the mail. Yeah, I remember that. Yeah, my bad. I was like, oh my God, like what type of state
Did he just say he checked that while he was driving?
you live in? The appellate judge writes complained about black people serving on the jury when I saw that. I remember.
And you said you.
What the heck? Were you guys really talking about alcohol? What? The heck? I missed it. I'm so sad.
You said you almost hit the floor.
Yeah, literally. And I went, I was out of it for a while.
Now tell me, do you see any mention of that on exhibit 63?
No. And this right here, Wallace's complaint that I found out today that she actually wrote she don't like the crude language I use, and I don't understand. I respect that. I understand that. I could have been more refined. I admit that. And for that, I do apologize. We are lawyers and not barbarians. But this wasn't in a court.
I can't remember. Peppermint, right?
Arbitration scene, me and Hubbard was going back and forth. So, but it's different. She don't complain about black people serving on jury here. I thought that's what she was complaining about.
Right.
But yeah.
Can you go to exhibit 55? That's base number 999.
Oh, that was one of the big things. See, he just messed up real bad, guys. So one of the biggest complaints he had was the judge saying that black people are serving on the jury, which would have been a big deal. Would have been. But he just said, oh, I thought she was complaining about black people serving on the jury. That's not what she says there. It's what he just said. Oh, man. I think he's going to get sanctioned. I don't think he's going to get disbarred. I think he's going to get censored. I don't know. But they're not done yet. They're not done putting on their case. There's still time for them to present any evidence. Did they present any evidence while I was gone? I was not able to listen. Anything? Probably not, because you guys would have told me.
All right. There's 5 there.
What is that document?
Oh yeah, this is the Supreme Court's decision after the Civil War, and is Stroud versus West Virginia, and they said that black people it's like the foundation for the subsequent like Batson versus Kentucky cases. You can't discriminate in jury selection. You can't exclude black people. That's a crime. And this decision was after the Civil War and slavery, and it was really they had that's that decision. You can't discriminate against black people. We don't live in the dress code anymore. And That's what I was actually thinking this case in Batson when I had what I thought was Wallace's complaint. And that's what I was terrified at that point. But I feel relieved now that I know she didn't. I can understand why she complained about some things. I get that. I totally disagree with her ruling. I tell you that on the substantive merit of the case.
Yeah,
but
Kyle,
I am relieved that she didn't write a complaint saying
I wanted him to
that
win.
black people, the issue about black people serving on jury.
For this last portion of Mr. Bell's testimony, I ask that we go off the live stream.
And that's exactly what they do.
Okay, and I imagine that will take us to the end of today, so I think it means that we'll be off the live stream for the rest of today's proceedings.
Mr. Duckett, how long do you think that you have left for Mr. Bell's testimony?
10 minutes.
Okay. Sarah, if you can stop the live.
Boop. So, he has 10 minutes left, couple questions left, and then the Bulldog gets to ask her questions. And this is when she should, so at the beginning, I don't know her name. I'm just going to call her the Bulldog because I don't know her name and it fits. She is. So at the beginning, all she was doing was introducing evidence. If you remember, the evidence that she introduced were the lawsuits that he had against all those other lawyers and the lawsuits that he had against all those other judges. And I think we were up to 4. Was it? It had to have been more. Because this might be at least 4. A minimum of 4 times that judges have complained to the Office of Disciplinary Counsel about his conduct in court and the things that he says in court. Okay, so tomorrow's the last day. I don't know if it's 4 hours or 6 hours, so I don't know if we're going to do it all. And we will not get a decision now because what this board is going to do is it's going to make a recommendation to the Supreme Court. And then we're going to find out from the Supreme Court what happens to him. Probably in a month or 2, maybe. I don't know. I'm going to keep an eye on it. But we're going to find out what she does to him tomorrow. I can't say it's going to be pretty. It's not going to be pretty. But tomorrow there's probably going to be some sparks. So actually, when I say tomorrow, I mean in about 6 hours. We'll do the first part in 6 hours. So thank you so much for coming out, guys. I really, really, really appreciate it. Thank you, Tiffany, for watching chat. Thank you, Mods, for watching chat. I really appreciate it. I do. I'll see you in a couple hours. Go get some rest and behave, okay? Thanks, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. and see for